Okay, so let's talk about the Sixth Amendment. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Wow. So the Sixth Amendment talks about criminal prosecutions, and it says a speedy trial. Yeah, you have the right, you, not criminals, not bad people, everybody, you have the right to a speedy and public trial. Nothing secret. Everything has to be out in the open by an impartial jury. That's why we have voir dire, so that we can make sure that we select in juries that are going to hear the case, juries that are fair and impartial for both sides, not just the defense. The prosecution also has the right to a fair trial. And it has to be done in the same district where the crime occurred. Okay, there's jurisdiction. It wouldn't be fair, right? If, let's say, they accused you of a crime, we're going to try the case in New York, and you're from here, from Brownsville. How are you going to bring in your witnesses that will help you? How are you going to transfer them all the way to New York City? So that's why we have that law there that, helps prevent the government from doing those types of little games that will jeopardize justice, that will jeopardize justice, because then an accused will not be able to bring any witnesses because he won't have any money or they don't want to travel all the way to New York. So it has to be done in the same district where the crime occurred, nearby. He also has the right of notice. It says here, and to be informed of the nature. So you have a right. We have the right to know, what do you accuse me of? That's what the indictment is for. That's what the complaint is for. That's what the information is for. Those three charging instruments that we talked about, they're not only charging instruments to accuse, but also to give notice, because the Sixth Amendment says you are entitled to know what are the charges. What are you accusing me of? And that comes from the Sixth Amendment. And you have the right to be confronted with witnesses against you. Yes. That comes from, if you're going to accuse me of something, you got to say it to my face. So that's why a piece of paper is not good enough. I've had a lot of, in my career as a lawyer, I've had some people say, I've been a prosecutor almost all my career, except for 10 years that I was a defense attorney. And I have witnesses, and I say, hey, you got to come to court. No, I don't. I already wrote a report, and I already gave a statement to the police. Why do I need to show up? Because the Sixth Amendment gives the right to the accused to confront the witnesses that testify against him and to cross-examine them. And they cannot cross-examine your report or your statement. So you have to go to the court and live testify and say, yes, I point to you and you did this and I saw you do this. Why? Because of the Sixth Amendment. It's a sacred right. It is so sacred that even children that are victims, that are afraid, have to do it. Even children have to do it. They have to confront the one that they accuse of having raped them. And there's certain exceptions, but not many. And well, they're not exceptions. They're like, sometimes they allow them to do it on TV, but very rare. And there's a lot of hoops to follow. But even children that are victims have to testify live. A piece of paper is not good enough. Okay. But what we're here for is not to talk about that. Not to talk about, and to have compulsory process. What's compulsory process? Subpoenas. The defendant has the right to issue a subpoena, just like the state, to order people to come to court and testify on his behalf, in his favor. Yeah, that Sixth Amendment gives him that right. And a subpoena is an order from the court. If they don't come, they will be held accountable under contempt of court, and they could even go to jail. So yes, they have the right to issue subpoenas, orders. All they have to do is tell the court, I need these witnesses. Okay, so then the court will issue subpoenas, and those are orders. Hey, witness, you need to come and testify. And the defendants, the accused, have that right. They have that power. But like I said, this is not so much what I want to talk about, but what I also want to talk about is the assistance of counsel in his defense. The right to a lawyer. Now, the courts have interpreted the assistance of counsel to mean that people have the right to a lawyer in critical stages of a criminal case. So when do accused have the right to a lawyer? Let's talk about that. They have a right to a lawyer under the Sixth Amendment in all critical stages of the criminal case. The first stage is going to be the arrest. They're arrested. Do they have a right to a lawyer just because they're arrested? No. They don't have a right to a lawyer because they're arrested. What about if they're arrested and the police want to interrogate them and they're arrested? They're not free to go. Do they have a right to a lawyer? Yes. Yes, they do. But that would go more under the Fifth Amendment. But that's okay. Just for you to know, they do have a right to a lawyer if they are arrested, if they are in custody and the police want to interrogate them. The key here is custody plus interrogation. Custody alone is not enough. It's custody plus interrogation equals the right to a lawyer. Okay? Custody. They are not free to leave. And they are interrogated. Okay? So, do they have a right to a lawyer once they're arrested and they are taken to an initial appearance? Do they have a right to a lawyer at an initial appearance? No. You know why? Because nothing happens at an initial appearance. The judge tells the accused why he was arrested, whether he's the person that should have been arrested. There's some identification issues there. He also tells him his rights, and maybe they discuss something about the bond and stuff like that. But the key thing is the judge doesn't ask him any questions. He just gives him and provides him information, but doesn't ask any questions of him, doesn't interrogate the accused. Okay? Does he have a right to a lawyer? Does an accused have a right to a lawyer at the, let's say at grand jury? Do they have a right to a lawyer? No. He doesn't even have the right to be there because a grand jury is secret. So, no. Does he have a right to a lawyer at a probable cause hearing, also known as an examining trial? That's a hearing before he gets indicted by a grand jury. Before he gets indicted by a grand jury, if that hasn't happened, if there's no indictment yet, then the defense attorney can file a request for an examining trial, a probable cause hearing. And in that hearing, that's like a little, sort of like a little mini trial. Forgive me for using that word, but it's sort of like a little mini trial because it's in front of the judge, not in front of the jury. There's no jury, it's just the judge. And the issue is all about probable cause. Is there probable cause? A fair probability that this defendant committed the crime in the complaint? Because at that point, there's no indictment. Remember, I said that an examining trial occurs if the grand jury hasn't indicted him. And so therefore, the only issue is probable cause. So then the prosecution can call witnesses and they can get cross-examined. And the whole issue, the only issue, it's not whether he's guilty or not guilty, because that's up to a jury to decide. It's whether there's probable cause to believe that he may have committed the crime. So is the defendant entitled to a lawyer at the examining trial if one is requested? Yes. Yes. It's a critical stage. Okay. How about an arraignment? Remember what an arraignment is? The arraignment occurs after he's indicted, set to go to court, and the arraignment is where it's basically the same thing as an initial appearance, but this time they have an indictment. And so instead of reading the complaint, they read the indictment. The judge reads the indictment. But he does one more thing. At the initial appearance, all the judge does is read the complaint and tell him what he's accused of. But at the arraignment, the judge does something else. He asks one question. How do you plead? Guilty or not guilty? Because he asks that one question. Does he have a right to a lawyer at arraignment? Yes. 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 Okay? All right. Then after the arraignment, from then on, he has a right to a lawyer. At the trial, at motions to suppress, at appeal, after that, at sentencing, at appeal, he has a right to a lawyer. Okay? All right. So I'm going to stop here and we will continue on later on. Thank you.